Visa Assistance is not a law firm. We do not provide legal advice. This information is for educational purposes only, based on past experience with H2 programs, is not to be considered as engaging in rendering legal, immigration, and/or other professional advice. Should you feel you need legal advice, please contact a board-certified attorney or a tax professional.
Hi, my name is Douglas, and on behalf of our staff at Action Visa, I'd like to welcome you to our webinar on understanding your job order. This is a blank ETA Form 9142. It's an application for a temporary employment certification. This form becomes an enforceable contract between you, the employer, the government, and the worker. The job order, as we'll call it today, details all the information about the employer, the job, compensation, etc., and employers must follow the terms of this contract to the letter. The job order is the document that will either support you during an audit or serve to hang you if you are not following the terms of the contract or the rules of the program. When your workers have been granted visas and are on their way to you, we send a wrap-up email with information for the onboarding of your workers, and we include this, a copy of your profile, which is a copy of the terms under which your workers were hired. It's important that you know this information and that you follow the terms of the contract. Please know that the Office of Foreign Labor Certification and the U.S. Department of Labor Wage and Hour Division both have concurrent jurisdiction and the authority to impose fines and sanctions under the program regulations as well as under Title 29, Statute 503.24. The program has several regulatory requirements for the minimum information that must be included in the job order. These are the assurances the employer is guaranteeing. It's important for employers to understand the language in the job order, and it's important to note that by submitting your application for temporary labor, you've already agreed to abide by the following program rules and regulations. Any requirements that the employer has for experience or other qualifications, as well as the benefits, wages, and working conditions, must be equally required of and extended to both U.S. and H-2 workers. There can be no preferential treatment or discrimination either for or against U.S. or H-2 workers. All the workers must be treated the same. Any qualifications or any other requirements that the employer may have for the job must be the norm for your industry, and they must be applied equally to both U.S. and H-2 workers alike. The job order must include the employer's name and contact information, as well as state that the job is a temporary full-time position and also show the number of positions that are open. The information for the job has to be sufficient enough to inform a worker about the services or labor to be performed, including the duties of the job, as well as any requirements or qualifications, the work hours, the days of work, and the start and end dates of the job. Anything that would prevent a worker from being hired, such as a felony conviction or the failure of a drug test, must be included in the job order. And please remember that anything the workers could be doing as a part of your normal operations, should bad weather prevent them from doing their normal duties, should also be taken into consideration. The workers have to know where they are going to be working. This is called the geographic area of intended employment, and the workers can only work within that approved area. The workers also need to be made aware of any commute that may be involved and the area in which they may have to reside. The job order must specify the wage that the employer is offering and will provide to both H-2B and corresponding U.S. workers. The wage offer must equal or exceed the highest of either the prevailing wage or the federal, state, or local minimum wage. If overtime is available, the number of hours available to the worker and the wage offer for working any overtime hours must be stated on the job order. If applicable, it must also be stated that on-the-job training will be provided to the worker. The employer must use a single work week as its standard for computing wages due and must specify the frequency with which the worker will be paid, which must be at least every 2 weeks or in accordance with prevailing practices in the area of intended employment, whichever is more frequent. If the employer is going to offer any assistance to workers, such as assistance with housing, or if the employer is offering any fringe benefits, those must be listed on the job order as well. Any and all deductions from the worker's pay, including lawful payroll tax deductions, must be disclosed in the job order. Deductions cannot be for the benefit of the employer and may not lower the wages of the worker below the set hourly wage in the job order. The Fair Labor Standards Act, or FLSA, also applies to the H-2B program, and there are regulations for determining fair or reasonable cost. If the worker completes 50% of the period of employment that's covered by the job order consistent with the regulation in 655.20J, the workers must be reimbursed for transportation and subsistence from the place from which the worker has come to work for the employer, whether in the U.S. or abroad, to the place of employment. The employer must provide or pay for the worker's cost of return transportation and daily subsistence from the place of employment to the place from which the worker departed to work for the employer. And if applicable, the employer must also state if they are going to provide daily transportation to and from the work site. If the employer is offering transportation to and from the work site on a daily basis, this must be offered to both the H-2 and the corresponding U.S. workers. The employer must reimburse the H-2B worker during the first work week for all visa processing, border crossing, and other related fees, including those mandated by the government incurred by the H-2B worker. The employer must provide to the worker without charge or a deposit charge all tools, supplies, and equipment required to perform their duties assigned in accordance with the regulations. The employer must offer the worker employment for a total number of the work hours equal to at least 3/4 of the work days of each week covered by the job order in accordance with the regulation. The employer must instruct applicants to inquire about the job opportunity or send applications, indications of availability, and/or resumes directly to the nearest office of the state workforce agency in the state in which the advertisement appeared and include the state workforce agency contact information. Actions that can cause an employer to be penalized, fined, and even debarred from the program include, but are not limited to, one or more acts of commission or omission which involve the following: failure to pay or to provide the required wages, benefits, or working conditions to the employer's H-2B workers and/or the U.S. workers in corresponding employment. Failure, except for lawful job-related reasons, to offer employment to qualified U.S. workers who applied for the job opportunity for which the certification was sought. Failure to comply with the employer's obligations to recruit U.S. workers, or an improper layoff or displacement of U.S. workers or U.S. workers in corresponding employment. Failure to comply with one or more sanctions or remedies imposed by the administrator of the Wage and Hour Division, the Office of Foreign Labor Certification, or the Secretary of Labor under a court order. Impeding an investigation of an employer under this part can get you debarred, but subparagraph 7 addresses 3 things that can get employers in trouble. 1. Employing an H-2B worker outside the area of intended employment. 2. In an activity or activities not listed in the job order. And 3. Or outside the validity period of employment on the job order, including any approved extensions. If any of your workers have paid any type of a fee in order to get a job, even if hired by a foreign labor recruiter, that is a violation. If any of your hiring practices are determined to be discriminatory either for or against U.S. or H-2 workers, that is also a violation. You may also be barred from the program or penalized for any other act showing such flagrant disregard for the law that future compliance with program requirements cannot reasonably be expected. You can also be penalized and barred from the program for fraud involving the H-2B registration, the application for prevailing wage determination, the application for temporary employment certification or the H-2B petition, or any material misrepresentation of fact during the registration or application process. And now we have a few items or food for thought for employers. Employers need to remember that the workers are assigned to your federal employer identification number, and they can only work for you and only during the authorized period of time on their visa. To use them for a few days after the contract term expires, or to have them start working before the official start date, is a violation of the program regulations. The date they must be out of the country is stamped on their I-94. Unless the specified wage for the contract lowers the wages of the U.S. corresponding workers. Any U.S. worker who is doing the same work as the H-2B workers during the valid time of the contract is considered as being a corresponding worker and is entitled to the exact same job terms, wages, and benefits that the H-2B workers receive. The statute 503.24 subparagraph 7 states that it is a violation to have workers performing any activity not listing on the job order. We recommend that you consider the things that happen to prevent the workers from being able to do their primary job, and bad weather is the most common factor. What could the workers be doing? Now, this must be a part of your normal operations, but not necessarily done on a frequent basis, such as light equipment maintenance, cleaning the shop, or conducting inventory. These must be included in the job order as a possible part of their duties. Otherwise, if not listed, the government may very well view it as fraud and the workers can't perform those duties. That concludes our webinar on the job order. Thank you for attending.